The call came in on a Wednesday morning, just after 9. The voice on the other end belonged to a man named Preston Cole. He was the lead counsel for Hartfield Energy Solutions, a mid-size extraction company operating across 4 states. He had handled drilling contracts, land disputes, and permit battles for 19 years. He did not rattle easily. But he was rattled now. "We have a problem with the Greer County permit." The project manager on the other end went quiet. The entire extraction contract, the $2.1 million agreement with Consolidated Energy, it's blocked. Blocked by what? A boundary claim, filed 18 months ago. Nobody flagged it. How much is the claim worth? $3. Silence. $3 in assessed boundary value, filed by a woman in Greer County, a farmer's daughter. Nobody paid attention to it because nobody thought it mattered. But it mattered. It mattered because that $3 discrepancy sat inside a deed description tied to a 1979 handwritten will, and inside that will, buried in paragraph 9, was a mineral rights clause that had been sleeping for 44 years. The lawyer who laughed at the claim in open court had not read paragraph 9. He should have. Her name was Loretta Vane. She was 61 years old, gray at the temples, deliberate in every movement she made. She had grown up on 12 acres of unremarkable bottomland in Greer County, Tennessee. She drove a 10-year-old truck and kept her receipts in a shoebox under the kitchen counter. Most people in town knew her as the woman who grew up in the old Vane place off County Road 7. Nobody knew what she had been quietly holding since the summer of 2006. And it all began not in a courtroom, not in a bank, but in a county clerk's office on a Thursday afternoon in September of that year. The office smelled like old paper and floor wax. A single ceiling fan turned slowly overhead. The clerk behind the counter, a heavyset man named Dale Pruitt, had worked there for 22 years and had never once seen anyone request what Loretta Vane requested that afternoon. "I need the original survey file for parcel 14B, the Vane estate filing, 1979. Pruitt looked up from his desk. "That filing is over 25 years old." "I know what year it is," Loretta said. He found the file after 11 minutes of searching, a manila folder, soft at the edges. Inside, a handwritten will, a property survey, a notarized boundary description, and a single page of mineral rights addendum that had been stapled to the back and never separated. Loretta sat at the small reading table by the window. She read every page once, then she read them again. Then she turned to the mineral rights addendum and read it a third time, slowly, line by line. She set the page down. She looked out the window at the parking lot for a long moment. Then she asked Pruitt for a photocopy. He charged her 30 cents. She paid with exact change. She folded the copy, placed it in the inside pocket of her jacket, and drove home without stopping. To understand what Loretta saw in that document, you have to understand something about her mother, Ruth Vane. Ruth had been a careful woman. Careful with money, careful with words, careful with land. She had grown up watching her own father lose 40 acres in a tax dispute he never fully understood. That loss shaped everything that came after. When Ruth wrote her will in the autumn of 1979, she did not use a lawyer. She wrote it by hand at the kitchen table, the same table where Loretta now took her coffee every morning. Ruth had read 2 books on Tennessee property law before she put pen to paper. She wanted to make sure that whatever she left behind stayed exactly where she intended it to stay. The mineral rights clause in paragraph 9 was 6 sentences long. It stated that any subsurface rights attached to parcel 14B were to remain with the named heir and could not be transferred, leased, or encumbered without the heir's written consent, regardless of any future survey correction or boundary adjustment. 6 sentences, 44 years. Nobody had read them. Loretta had known about the will since her mother passed in 2003, but she had never requested the original survey file until the summer of 2006, and only then because her daughter had mentioned something on Sunday dinner that stopped Loretta mid-sentence. "Mama, did you know they're doing seismic tests out past County Road 7? Loretta set down her fork. "Who is?" "Some energy company. 2 trucks came through last Tuesday. They were out there most of the day."
Loretta said nothing for the rest of the meal. That night, she sat on the porch for a long time, looking out toward the dark tree line past the road. Her husband Roy watched her from inside through the screen door. He had known her for 31 years. He knew the difference between her thinking and her deciding. She was deciding.
The $3 discrepancy was not something Loretta stumbled onto. She had been looking for it. In the spring of 2009, she requested a second document from Dale Pruitt's office, the original 1978 boundary survey for Parcel 14B, the one conducted before her mother wrote the will. Pruitt found it in 20 minutes this time. He was getting used to her. She took it home and laid it flat on the kitchen table beside the 1979 will. The boundary descriptions did not match. Not by much. A single measurement on the southeastern corner read 208.4 feet in the survey. The will's legal description read 208.7 feet, a difference of 0.3 of a foot. At the county's assessed rate for that land class, the discrepancy translated to a taxable value difference of exactly $3. $3. Under Tennessee property law, an uncorrected boundary discrepancy between a filed survey and a recorded deed description created what was called a defective legal description. It was rare. It was almost always harmless. Lawyers dismissed it routinely because correcting it cost more in filing fees than the discrepancy was worth. Unless the deed in question contained a clause that attached subsurface rights to the legal description as written. In that case, any quiet title filed against the property, any attempt by a third party to claim those subsurface rights through adverse possession or blanket mineral lease, would rest on a defective legal foundation. Hartfield Energy had filed a quiet title across the entire southwestern corridor of Greer County in March of 2019. Parcel 14B was included in that filing. They had paid their lawyers well to make sure every parcel was clean. Every parcel except one. Because on Parcel 14B, the legal description as written in Ruth Vane's 1979 will did not match the boundary bearing, and that will, with its mineral rights clause in paragraph 9, had never been superseded, never been challenged, never been amended. Loretta had known about the quiet title filing for 11 days before she drove to the courthouse. She brought 2 documents, the original survey, the original will. She filed a boundary correction claim on the southeastern corner of Parcel 14B. The assessed value of the corrected measurement, $3. The clerk at the filing window, a young woman named Ashley who had started the job 4 months earlier, looked at the paperwork for a long moment. "Is this a $3 claim?" Loretta set her hands flat on the counter. "That's correct." Ashley looked up. "Ma'am, the filing fee is going to be more than the claim itself." "I know what the filing fee is," Loretta said. She paid $45. She took a receipt. She walked back to her truck in the parking lot, sat for a moment with both hands on the wheel, then drove home. Roy was on the porch when she pulled in. "Did you do it?" "Done." He looked at her. "You want coffee?" She was already at the door. "I'll make it." They sat at the kitchen table for a while without talking. The green notebook was in the drawer, 3 feet away. Loretta did not open it. She already knew everything that was in it.
She had not expected it to move quickly. It didn't. Hartfield's legal team received notice of the boundary claim 6 weeks after she filed it. Their response came through a Nashville attorney named Graham Lyle. He was 44 years old, had argued 11 cases before the Tennessee Court of Appeals, and had a reputation for efficiency that bordered on arrogance. His letter arrived on a Tuesday morning. Loretta read it standing at the kitchen counter. It was 4 paragraphs. The first paragraph dismissed the claim as immaterial. The second questioned her standing to file. The third cited 3 precedents. The fourth requested that she withdraw the filing within 30 days or face a counter-motion to dismiss. She folded the letter, put it in the drawer with the notebook, did not respond. 30 days passed. Lyle filed the counter-motion. Loretta called a woman named Cecile Drummond. Cecile was 53, a property and mineral rights attorney based in Knoxville, sharp-voiced and unimpressed by most things. She and Loretta had gone to the same high school 38 years earlier.
They had not been close then, but when Loretta explained what she had, Cecile went quiet for almost a full minute. Then she said, "Read me paragraph 9 again." Loretta read it. Another silence. "Loretta, how long have you had this?" "Since 2006. And Hartfield's quiet title was filed in 2019. "That's right." Cecile exhaled slowly. "Their entire mineral rights position in that corridor rests on a clean title to 14B. "I know. If the legal description is defective, the clause doesn't transfer." Cecile was quiet again. "You filed the $3 claim to force the defect into the record." Loretta looked out the kitchen window toward the backfield. "I filed it because it was accurate." The hearing was set for February of 2020, Greer County Circuit Court. A Tuesday morning, cold and gray, frost still on the windshields in the parking lot. Graham Lyle arrived with 2 associates and a leather document case. He set up on his side of the courtroom with the practiced ease of someone who had never lost a boundary hearing in his career. Loretta arrived alone. She sat on her side of the courtroom in a plain dark jacket and set one folder on the table in front of her. Cecile sat beside her, said nothing. Lyle addressed the judge with confidence. The claim, he argued, was a nuisance filing, a manufactured technicality. A $3 discrepancy from a 40-year-old handwritten document carried no legal weight against a properly executed quiet title. He used the word immaterial 4 times. He smiled once toward the gallery when he said the amount out loud. $3, Your Honor. This is what we're here about today." A few people in the gallery shifted. Someone made a sound that wasn't quite a laugh but was close enough. Loretta looked straight ahead. Cecile stood. She placed 3 documents on the table: the 1978 survey, the 1979 will, Hartfield's 2019 quiet title filing. Then she said one thing. "The quiet title rests on a clean legal description of parcel 14B. That description has been defective since 1979. The claimant did not create the defect, she simply filed it correctly." Lyle interrupted. "A $3 boundary variance is not a defective." The judge raised one hand. He looked at Cecile. "Does the 1979 will attach mineral rights to the written legal description specifically?" Cecile turned to page 3 of the will. "Paragraph 9, Your Honor, verbatim." The judge read it. He read it again. He looked at Lyle. "Does your client dispute the authenticity of this document?" Lyle hesitated. "No, Your Honor, but the variances—" The judge set the document down. "A mineral rights clause attached to a specific legal description cannot transfer on a title that does not match that description. The boundary claim stands. Motion to dismiss is denied." Lyle stood very still for a moment. Then he sat down. Loretta did not move. She did not look at Lyle. She did not look at the gallery. She picked up her folder from the table, straightened the pages, and placed it back under her arm. Cecile leaned toward her. "That's it?" Loretta nodded once. They walked out into the cold parking lot. Loretta unlocked her truck, got in, sat for a moment. Then she opened the glove compartment, took out the green notebook, and wrote 4 words. February 2020. Claim upheld. She put the notebook back, started the engine, drove home.
Hartfield Energy Solutions did not call that afternoon. They called 3 days later. Loretta was pulling weeds along the fence line behind the house when Roy came out and told her there was a man on the phone from Nashville. She pulled off her gloves, walked inside, picked up the receiver. "Mr. Vane?" A smooth voice, measured, careful. "Mrs. Vane," Loretta said. A brief pause. "Mrs. Vane, my name is Carson Webb. I'm the Regional Director for Hartfield Energy. I'd like to discuss Parcel 14B with you directly." She said nothing. "We believe there may be a path forward that works for everyone involved. We're prepared to offer $180,000 for a full mineral rights transfer, clean close, no further litigation." Loretta looked at the calendar on the wall beside the refrigerator. February 14th. She almost smiled. "I appreciate the call," she said. Webb sounded encouraged. "So you're open to discussing?" I said I appreciate the call. She set the receiver down. Roy was in the doorway. He had heard enough. How much? $180. He let out a slow breath. Loretta. She was already walking back toward the door. I've got fence line to finish. She called Cecile that evening. They offered $180,000. What did you say? I hung up. Cecile paused. Good. What do you want? Loretta had thought about this for a long time, not since the phone call, since 2006, since the night she sat on the porch looking at the tree line and felt the shape of something she couldn't yet name but could clearly see. I don't want a sale, she said. I want a royalty agreement, structured payments tied to extraction volume, transferable to my children, adjusted annually. Cecile was quiet for a moment. That's not what they want to give you. I know what they want to give me. Another pause. Then Cecile said, I'll make the call tomorrow.
Carson Webb did not take the call himself the second time. He sent Graham Lyle instead, which told Loretta everything she needed to know about how seriously they were now taking this. Cecile outlined the terms, a royalty rate of 4% of gross extraction value on any subsurface activity within or adjacent to Parcel 14B. Minimum annual payment of $60,000 regardless of extraction volume. Transferable in perpetuity to Loretta's heirs. No buyout clause, no expiration. Lyle's response was immediate. That's not a negotiation, that's a demand. Cecile stayed calm. Yes. Lyle pushed back hard over the next 2 weeks. He sent 3 counterproposals. The first offered a flat $300,000 buyout with a 5-year non-litigation agreement. Loretta heard it and said 2 words, tell him no. The second offered a 15-year royalty agreement capped at $40,000 annually with a buyout option at year 10. Loretta listened to the full summary. Then she said 2 words again, tell him no. The third offer was a hybrid, $150,000 upfront, reduced royalty rate, 20-year term. Loretta didn't even finish hearing it. No. Cecile called Lyle back. 4%, $60,000 minimum, permanent. Those are the terms. They don't change. Lyle was quiet for a long moment. Mrs. Drummond, your client needs to understand that Hartfield has resources and patience for a protracted dispute. Cecile looked across her desk at the wall. So does she. She's been patient since 2006. How long has your client been patient? Hartfield disappeared for 3 weeks. Loretta went about her days. She fixed a section of fence on the north pasture. She drove her granddaughter to a school recital in town on a Thursday evening. She cooked Sunday dinner and did not mention mineral rights or Hartfield or Graham Lyle. Roy watched her carefully across the table and said nothing. He had learned a long time ago that her stillness was not emptiness, it was weight. Controlled, deliberate, immovable weight. Then Hartfield came back, not with Lyle this time, with a different lawyer, a woman named Patricia Hurd from a larger firm in Memphis. Hurd had a reputation for closing difficult cases. She called Cecile directly and spent 40 minutes outlining a new legal theory. The argument was precise. The 1979 will, she claimed, had never been properly probated under Tennessee's formal requirements. If the probate was defective, the mineral rights clause had no legal standing. No standing meant no defect. No defect meant the quiet title was clean. Cecile listened to the full argument without interrupting. When Hurd finished, Cecile said, I'll need 2 days. She called Loretta immediately. They're attacking the probate. Loretta was silent for a moment. On what grounds? Hurd claims your mother's will had never been formally submitted to probate court. Another silence, longer this time. Then Loretta said, look in the file I sent you, the brown envelope, behind the survey documents. Cecile found the envelope. Inside were 4 pages held together with a rusted paperclip. She unfolded them carefully. The original probate filing, Greer County Probate Court, submitted October 3, 1983. Stamped, signed, and recorded by the presiding judge. Cecile stared at it. Loretta, where did you get this? My mother kept everything, Loretta said. I kept everything she kept. How long have you kept this? Since the day we cleaned out her house, 2003.
Cecile set the page down on her desk. She had been practicing law for 26 years. She had seen careful clients before. She had never seen one this careful. You kept this for 17 years. Loretta's voice was steady. I kept it because my mother kept it. She kept it because she knew that someday someone would say the will didn't exist. She wanted to make sure there was no room for that argument. Cecile picked up her pen. I need to make a call.
The second hearing was shorter than the first. Patricia Hurd presented the defective probate argument with precision. The gallery was fuller this time. Word had gotten around Greer County that something significant was happening in courtroom 2 on a Wednesday morning in April. Cecile placed the probate filing on the table. Stamped, dated, signed, recorded in 1983. She said one sentence. "The will was probated 41 years ago, Your Honor. We have the original filing." Hurd looked at the document for a long moment. The judge looked at Hurd. "Does your client dispute this record?" Hurd straightened her papers carefully. She took a breath. "No, Your Honor." The judge looked at Hurd for another moment, then at Cecile, then back at the probate filing on the table. The mineral rights clause stands. The quiet title remains defective as filed. Case closed. Lyle was not in the courtroom that day. Hurd packed her documents in silence. She did not look at Loretta on her way out. Loretta sat still until the room was nearly empty. Then she stood, buttoned her jacket, and walked out into the April morning. The frost was gone. The trees along the courthouse square had just begun to show green at the edges. Cecile fell into step beside her. "That's twice now." Loretta kept walking. "They'll call today." They called before noon. Carson Webb again. The smooth voice was still there. The measure was gone. "Mrs. Vane, our client is prepared to accept your terms." Loretta stood at the kitchen window, looking out at the back field. "All of it?" 4% royalty, $60,000 annual minimum, permanent agreement, transferable to your heirs. "Yes, all of it." She set the phone down gently, not a slam, just a soft click of the receiver finding its place. Roy was at the table. He had heard. He didn't ask anything. He just looked at her for a long moment. She sat down across from him, pulled the green notebook from the drawer, opened to the last written page. Below the February 2020 entry, she wrote one line. April 2021. Done. 3 weeks later, the agreement was signed and filed at the Greer County Clerk's office. Loretta filed it herself. She drove alone, parked in the same lot where she had parked in September of 2006 when she first requested that manila folder with the soft edges. She walked through the same door. Dale Pruitt was still behind the counter. He was close to retirement now, heavier, slower. He looked at the document she slid across the counter. He read the royalty figure. Then he looked up at her. "Is this the Vane parcel, off County Road 7? "That's right," Loretta said. He stamped it, filed it, handed her the copy. She folded it once, placed it in the inside pocket of her jacket, and walked back out to her truck. Graham Lyle read about the settlement 3 months later in a legal trade publication, a short paragraph, no names beyond the company. He had moved on to other cases by then. He did not remember the woman in the plain dark jacket. He did not remember laughing in the gallery. He had laughed at a lot of things over the years. He did not remember the ones that mattered. Loretta never knew whether he read it. She never would have cared. Loretta Vane paid $45 to file a $3 boundary claim that nobody thought was worth the paper it was written on. Her mother paid nothing. She just paid attention, wrote 6 careful sentences in a handwritten will on an autumn evening in 1979, and trusted that someone in her family would eventually read them. Loretta read them. Then she waited. 17 years from the day she found the document to the day the agreement was signed. 17 years of driving past orange survey flags and writing plate numbers in a green notebook and saying no to every offer that came before the right moment arrived. Hartfield Energy Solutions had teams of lawyers. They had title researchers and regional directors and Memphis firms on retainer. They had resources and patience for a protracted dispute. Their lawyer said so himself. What they did not have was a shoebox of receipts and a mother who never threw anything away. Some people hire the best lawyers money can buy. Loretta just kept her mother's paperwork. If you believe that quiet people with long memories always win in the end, subscribe now. And tell me in the comments, would you have taken the $300,000 buyout and walked away, or waited for the permanent deal like Loretta did? I'll see you next story.